In today's video, I want to take a look at the question of restrictive covenants or non-compete clauses in the employment contract. Non-compete clauses are quite common. The fancy name or the legal name for these types of clauses are restrictive covenants. And a lot of employment contracts, especially contracts for middle management or top management positions, will have restrictive covenants, various restrictive covenants. The one that I'm referring to in this video is you will not take up employment for a certain period of time after leaving this job. That's the type of thing I'm talking about, non-compete, employment, restrictive covenant. Now, very interesting case, high profile case, was heard in the High Court in December of 2019 involving Ryanair and a top manager called Peter Bellew. Bellew was to leave the job with Ryanair. There was differences in his relationship, or maybe perhaps a breakdown of his relationship with Ryanair and with the CEO Michael O'Leary. And between the jigs and the reels, Peter Bellew was to leave his job and join EasyJet. EasyJet is a competitor of Ryanair, and O'Leary and Ryanair decided that they would have to point out to Mr. Bellew that there was an employment contract, restrictive covenant, preventing him from working in the airline industry for a period of 12 months after leaving Ryanair. And on that basis, Ryanair went to the High Court and sought an injunction to prevent Mr. Bellew from taking up employment with EasyJet. The question was, and this was Mr. Bellew's position, that the restrictive covenant was unenforceable because it was a restraint of trade and it affected his constitutional right to earn a living. Like all rights, the right of an employer or the right of an employee, courts are often tasked with the job of balancing the rights, the conflicting rights. So on the one hand, an employer has a right to restrict to a certain degree an employee who's departing from disclosing, for example, confidential information, and perhaps has a right to restrict employment for a certain period of time. And on the other hand, the employee has a right to earn a living and a constitutional right to earn a living and not be involved in any sort of a restraint of trade. In this particular case, however, the contract of employment said that for a period of 12 months after the termination of your employment, you shall not, without the prior written consent of the company, directly or indirectly in any capacity, either on your own behalf or in conjunction with or on behalf of any other person, be employed, engaged, concerned or interested in any capacity in any business, wholly or partly in competition with the company for air passenger services in any market. That, to anybody's reading, is fairly wide, is very wide in fact, and that was for a period of 12 months. The High Court then had to decide whether that was void or was it enforceable. The company or the High Court recognised that restrictive covenants were enforceable and were acceptable, provided the restriction was reasonable between the parties and provided that it was in pursuit of a legitimate objective. The High Court in this particular case, December 2019, looked at all of the case law in this area. However, it did find that the restraint that Ryanair sought to impose went further than what was necessary for the legitimate protection of its interests, went further than, and for that reason the High Court decided that this particular clause was void and unenforceable and was an unjustified restraint of trade. So essentially, there is nothing wrong with restrictive covenant, there's nothing wrong with a non-compete clause, but it must not go beyond what is a legitimate pursuit, a legitimate objective of the employer. If it goes too far, if it's unreasonable, it will be struck down and held to be void for an unjustified restraint of trade. Now, there is particular situations where a court can actually decide that a particular clause, for example for 12 months, is unreasonable and unjustified, and substitute a 6-month period, for example. But in this particular case, the way that the contract was drafted, the way that the restrictive covenants were drafted, it wasn't actually possible for the court to tweak it or to cut out a part of it because it was a whole, as it were. For this reason, it was void and unenforceable. So Bellew could go on then and work with EasyJet, and Ryanair were refused their injunction because really 2 reasons. One, the restraint preventing the departing employee, Mr. Bellew, from working with any European airline went beyond what was justified. And 2, the restraint preventing Bellew from taking up employment in any capacity goes beyond the legitimate interest of Ryanair and was not justifiable. For these reasons, the court struck it down. The takeaway for employers, the takeaway for employees is that a restrictive covenant is fine and enforceable and acceptable, provided that it doesn't go beyond what is justified in pursuit of a legitimate objective. So employers need to understand that a one-size-fits-all approach in relation to restrictive covenants in contracts will not cut the mustard and will leave you open to the restrictive covenant being held to be void and unenforceable. Interestingly, the 12 months as a temporal restraint is acceptable and was unproblematic according to the High Court. But the restrictive covenant in this case, the High Court case of Ryanair and Peter Bellew, saw a restrictive covenant that was far too wide and was not going to be acceptable, not going to be justified. Interestingly as well, the High Court made the point that confidentiality clauses in contracts of employment, whilst necessary and acceptable, are actually very difficult to enforce in practice because confidential information can be used and abused without any evidence of the breach. For example, if a top-level executive leaves a place, goes to a new place, has information in his head or her head, for example, about negotiations, about deals, about maybe rebates or discounts and stuff like that, that information obviously can be used or may be used without anybody knowing about it in the negotiations that follow. Anyway, this case, Ryanair versus Peter Bellew, it's a 2019, December 2019 case decision. It's interesting and it is a very good analysis, a very good review of the whole area of restrictive covenants in the contract of employment. And if you want to read the full decision and read a blog post that goes into it in more detail, you can go to my website, employmentrightsireland.com, and you'll find an analysis of that in a blog that I've written, a look at various previous Irish court cases involving restraint of trade and employment contracts and restrictive covenants, and you'll get a link then to the actual High Court decision. It's a long decision, but if you have an interest in this area of law, it's something that is worth your while having a look at because you'll be very, very knowledgeable about restrictive covenants in employment contracts after that. Hope you find this video useful. If you do, give us a thumbs up down below, and you may be interested in subscribing to my YouTube channel. If you are, hit the subscribe button down below and hit the bell button and you'll be notified every time I upload a new video. Thanks.